In 1812, Elbert Gerry was the governor of Massachusetts. He was a member of a political party that was opposed to the Federalists who were emerging into dominant power in the new national government. A political follower of Thomas Jefferson, who was an advocate of decentralized government. In Massachusetts in 1812, Governor Gerry, signed a districting plan that skewed the size and formation and shape of the districts in the Senate precisely to support and almost guarantee the candidates of his party would be elected. It actually worked. In the actual election in 1812, Gerry was defeated for re-election, and the state House of Representatives went Federalist. But the state Senate went as he had hoped and expected it to do, so that his decentralized oriented state Senate succeeded under his title. The political cartoon that appeared in the Boston Gazette showing the Senate district for the Essex area of Massachusetts, it shows what looks like a medieval reptile called a salamander. So obviously, after that cartoon appeared in the Boston Gazette, gerrymandering was forever known by that name. Now, there are two ways in which election districts can be gerrymandered. One of them can have a benign social, political, and cultural purpose. Generally, as you know, the Constitution does not tolerate the use of race to make public policy. And in fact, if any public policy or program or legislation uses race, it must satisfy the strictest constitutional test. It must, in other words, be absolutely necessary to the successful achievement of a government program for you to be allowed constitutionally to use race. But the Supreme Court, beginning particularly in the 1950s, was confronted with the reality that for generations, even though the 15th Amendment had guaranteed the right to vote to the freed slaves, and therefore to minority races, that Jim Crow laws had grown up and the right to vote was not a genuine reality for minority people in this country. After Brown versus Board of Education had succeeded in desegregating the public schools along terms of race, so that equality was a principle of children going to school, the court began dealing with the phenomenon of ending segregation in voting according to race. The 15th Amendment had tried to do that, but did not succeed because of the post-Reconstruction era Jim Crow laws. Finally, in 1965, Congress itself began moving aggressively to protect the right to vote for blacks, who obviously had gained citizenship by the 14th Amendment and should have gained the right to vote by the 15th Amendment of the Constitution, but did not. So the Supreme Court had to work out a system of, under the Equal Protection Clause, in which racial gerrymandering was to be allowed up to a certain point. And in a series of the more modern decisions in dealing with the right to vote, the court articulated the constitutional principle that you could use race if it were not the predominant factor. In other words, if you were using race primarily to use race in order to get the benefits of that, that was a constitutional violation of equal protection. So in a series of modern decisions, the Supreme Court has worked out what is constitutional and what is not constitutional in racial gerrymandering. The court has said when you bring a lawsuit to deal with your claim that race was used improperly, you can only bring this on the basis of what the impact of race was on your own election district. You cannot bring a statewide claim. It has turned out that in almost every term in which the Supreme Court sits every annual term, it has at least one or more cases dealing with attempts to racial gerrymander. Oftentimes this is not used for benign purposes. It is used for the specific political purpose of limiting the influence of black voters. The Supreme Court has made racial gerrymandering unconstitutional when you are weighting votes by race, and that is your sole purpose, even if you do it for what you think are politically favorable terms, like advancing the fortunes of one party. Now, before we conclude the lecture, I want to talk about one other form of gerrymandering. This is called partisan gerrymandering. It comes from the root, of course, that Governor Gerry, had planted in 1812. It has continued to be practiced by politicians ever since. And it has been said that in the 21st century, partisan gerrymandering has grown very, very much worse. In a phrase, what partisan gerrymandering really means is that the politicians who are getting elected are choosing the voters rather than the voters choosing the politicians. The Supreme Court has struggled with that for more than 40 years. It continues to struggle with that phenomenon because it has never closed the courthouse door to the idea that you can bring a claim that partisan gerrymandering involves too much partisanship. But it has never satisfied itself that there was a way by which judges could say this plan has too much partisanship in it. This is an inquiry that the Supreme Court continues to pursue. I remind you, it has not shut the courthouse door to this, but it has yet to find a workable formula.